Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello to all of our listeners. Thank you so much for joining us today. My name is Gina Bertolini, and I'm a partner with the law firm of K&L Gates in our healthcare and FDA practice group. I'm based out of Research Triangle Park, North Carolina. And joining me today are my colleagues, Stephen Page, who's a partner in our Nashville office, and Sarah Staples-Carlton, an associate attorney, also in our Nashville office. Sarah and Stephen are both with our healthcare and FDA practice group as well. And I should just mention, while K&L Gates is a international law firm, we have many offices throughout the country. We have many in the U.S., and our healthcare and FDA practice group is a national practice. And our colleagues in cross offices nationwide collaborate on issues like this, thought leadership issues, as well as representing clients. We often work together with our colleagues from our Nashville office and elsewhere. And today we're here to talk about the corporate practice of medicine doctrine. And one of the things that Sarah and Stephen and I have been talking about in our representation of clients, and in particular clients in the telehealth space, is that this doctrine seems to be coming up a lot in the questions we're getting from our clients. We often get those questions as they relate to structure and how to create an entity for clients that are new to the healthcare space or are just entering the healthcare space. But it seems like there's been a resurgence of questions. And so we thought it was a great time to just revisit this issue to really help our listeners understand fundamentally what is the corporate practice of medicine doctrine, as well as how does it impact them and how can they structure themselves so that they're compliant. And one of the really challenges here, which you'll learn about today, is if you're practicing or providing healthcare services in multiple states, it can be very challenging to comply with this doctrine because it is fundamentally a state-based doctrine. One of the questions we've been talking about, though, is, or as we think about this issue, why is it coming up again? And what I'll say, just to sort of set the table here as we get into this issue, is prior to the pandemic, federal healthcare programs really, by and large, did not reimburse for telehealth services, not in the way that they do now anyway. There were very restrictive site of service provisions, as well as restrictive provisions around the kinds of conditions and the kinds of treatment that would be reimbursed by, for example, Medicare and Medicaid. And commercial payers largely followed suit. And of course, with the pandemic and the requirement to provide care in remote care settings to keep people away from bricks and mortar healthcare facilities, we saw this explosion of telehealth. And it was, really as a means to an end in order to get through the emergency. And since then, we've seen many non-traditional healthcare providers enter the healthcare space. In many instances, these are for-profit entities, some of whom have not been in the business of providing healthcare previously. Some are private equity backed. And they're looking at providing a variety of services, sometimes in one, but often in many states throughout the country. And so they're going to run across the corporate practice of medicine doctrine. So that's what we're here to talk about today. I'm going to turn, Sarah, first to you with just a question of what is the corporate practice of medicine doctrine. But before I do, I will start with a hypothetical, just so that as our listeners, listen to this and hear us talk about it, maybe they'll have this hypothetical in mind. So what we see often is an entity that's structured as, a corporation or an LLC, does not have physician ownership, and it is interested in the provision of healthcare services via telemedicine, some remote care model. Maybe they're already doing it in one state and they're looking to expand their services across state lines. Maybe they're not doing this at all, but they're really looking to offer services in multiple states. The company is private equity backed or privately held, uses a telehealth solutions platform. Perhaps they have their own sort of a bespoke telehealth solutions platform, or they contract with a company that provides one. That is often the case. And they're looking to provide some sort of telehealth services, whether it's primary care, mental health, women's health, men's health, you name it, via telemedicine. They're considering having physician employees or independent contractors, but obviously they will have licensed providers who will be providing healthcare services via telehealth. So Sarah, turning to you first, can you tell us, does this company need to be concerned about the corporate practice of medicine doctrine? And if so, just help us understand, what is it?
Thank you, Gina. So I think what's important to remember is that the corporate practice of medicine is, like we said, it's a doctrine, right? And sometimes that doctrine will be codified in statute. Sometimes it is built on case law, but the underlying theme throughout is consistently, there's a public interest in ensuring the independent clinical decision-making of the provider. And so the corporate practice of medicine doctrine is designed in, different ways, depending on the state, to ensure that the physician remains in control of clinical decision-making and treatment. And so how that plays out is usually, on a most basic level, a prohibition on the direct employment of a physician by a corporation. And the way that, states have kind of, worked around this is to provide for a mechanism to form a professional corporation. There may be exceptions for specific types of healthcare providers, sometimes university systems, nonprofit systems, but in large part, for example, referencing back to our hypothetical, what our client in this instance would be looking at is, how do they form a corporate entity that would comply with this doctrine, allowing them to utilize physicians and deploy them on this telehealth platform. So really, really quickly, it is important to remember that policy motivation is the driving throughout. So when it comes to what counts as clinical decision making, consider that might be the kind of tests that are ordered in order to determine what a patient's concerns or conditions might be, or to determine a diagnosis, the medication that might be prescribed. All of these things should be firmly within the purview of the provider. And when you have a corporate entity employing a provider, the concern is that the provider will be primarily motivated by their employment relationship rather than the provider-patient relationship.
So it's almost, I've heard it called the corporate practice of medicine prohibition, right? It is actually the anti-corporate practice of medicine law in a way, because
absolutely,
its goal is to create separation between what might be profit-driven interests and the delivery of healthcare, it sounds like.
Yeah, and it is always interesting how that doctrine can, manifest itself, or how concerns about complying with that doctrine can show up, because, like I said, it seems very simple and very straightforward. Okay, well, I won't have an employee. We won't have them fill out a W-2. They'll be a 1099 or an independent contractor. But it goes further from, just the tax designation of this particular provider. It is, on a day-to-day basis, how does, what, influence might this private company have over the provider's relationship with the patient and their decision making. So it's important to remember that, just having the tax designation be appropriate isn't the end of the inquiry.
Yeah, so it sounds like you're saying there's more to it than just how you structure yourself or how you paper yourself. And one of the things I should have mentioned is this session is the first in a 2-part series on corporate practice of medicine that Sarah, you and Stephen, you and I will do, the three of us will do. We plan to spend our second session getting a bit more into the nuts and bolts of how an entity needs to not only structure themselves, but then also operationally function to comply with corporate practice of medicine. But you're raising a great point, which is there are requirements around how entities hold themselves out to the public, for example, the representations they make and the way they operate, the way they make decisions as between themselves within the entity, that all play into this or are relevant to this corporate practice of medicine doctrine.
We get questions around the gray areas of this doctrine all the time. And so I'm wondering if you wouldn't mind kind of addressing some of the common ones that we hear. The blanket, this doesn't make any sense to me. Why does this apply?
Yeah, so that's sort of the first one you get is this makes no sense. Why does this apply? We're just a tech platform, or we just provide business services, and we put in the agreement with the clinician that they have independent decision making, and shouldn't we be good? Shouldn't we be good? That's what we get a lot. And to your point, the underlying policy that the states have is to prevent non-clinicians from interfering. And that's been broadly defined. And what you have with the corporate practice of medicine is you have the courts looking at it, AG decisions, as well as statutes. And one example I like to use is in New York, and they have a very aggressive corporate practice of medicine as well as corporate practice of dentistry doctrine. And there was an AG enforcement action several years ago against a provider of business services to dental practices. And then it went into excruciating detail of what the regulator thought impinged upon clinical decision making. And include things like, so some of the things you would expect, like any clinical policy had to be reviewed and approved by a clinician. It couldn't be, created and approved by the business entity. And they actually had to have audit trails showing that clinicians had reviewed and approved these policies. And then you get into the sort of the relationship with the nurses or the dental assistants, and there were requirements around who could actually do this interviews, who could do screening interviews, who could do the performance reviews, who could sign the agreements. These all had to be clinicians. Who could terminate a clinician. Again, they all had to be dentists in this instance, and the physician context would be physicians. And then it went even into more detail around the financial operations. The clinicians had to control the bank accounts in which the money flowed. They had to approve any equipment decisions, clinical equipment decisions. And then lastly, as you said, Gina, how the entity was held to the public. There was a requirement that the clinical entity have a separate website, separate apart from the MSO, as well as any kind of advertisements had to be approved by the clinician. So it's a very expansive doctrine when you look at what the regulators look like. And that's just New York. You see similar efforts in California Board of Medicine. So essentially, that's one of the big objections is we're just a tech platform. We just provide business services. We don't really impinge upon the decision making.
Stephen, that's really helpful. And one of the things we should note is that not all 50 states and U.S. territories prohibit the corporate practice of medicine, but by and large, a majority do. That number is in the 30s. In terms of the number of states that prohibit it in some way, shape, or form. And as you mentioned, there's not quite a sliding scale, I wouldn't say, but there are some differences in the way different states enforce the doctrine. So one question I have for you that I know I've heard is, well, I'm in one state, I'm providing services, or maybe I've rolled out in 3 to 5 states, and they're not corporate practice states. So I should be good, right? I can roll out in these other states. What's your answer to that?
Sure, and it's a great question because in the brick and mortar context, the patient comes to your office, and the patient is in the clinical office. You know where the patient's located. In the digital context, you've got patients in various states, and so you may be based in a state which doesn't have a corporate practice of medicine, such as Florida, but then you're treating patients in other states. and you're on a digital platform. You have to kind of confirm where the patient is located, whether you're licensed in the state where the patient's located. So you do get a lot of mission creep in the digital space that you don't have in the brick and mortar space.
Yeah, I think that's a great point. And, I talked a little bit in my introduction about the explosion of telehealth. And, one of the things that we assume as lawyers practicing in this area, but we should make clear, one of the key differentials is exactly what you just said, that the site of service is generally where the patient is based. And so when you move into these remote models, you're away from a brick and mortar traditional model. You now have the site of service could be, anywhere in the country. You can have your physician in one state and your patient in another state. And so you've got to understand, where am I actually practicing medicine in that model, and then what laws apply. And so to your point, if an organization that's providing services in a couple of states is expanding its services and looking to provide care to patients sitting in multiple states, they're going to have to be aware of what those states' requirements are, not just in terms of the corporate practice of medicine, but in general, as it relates to practicing medicine or dentistry. And that's a broader subject we won't get into, but that's why it's challenging, but it's exciting to help our clients work through these issues, because it is, I think, a bit like, pulling off the layers of what do we need to know from a regulatory perspective to help them provide services. So, Sarah, I'll pivot back to you, because one of the things that we also hear a lot about, and we just wanted to make sure we touched upon, is fee splitting. Can you talk about what that is and how does it relate to corporate practice of medicine?
Yes, thanks, Gina. So really quickly, it's very easy to think of CPOM and fee splitting as, a package deal. And I will briefly explain. Fee splitting is essentially the splitting of professional fees with a non-professional. So, the fees that you as a provider, a physician receive for the services that professional services you provide, and sharing that with a non-provider, or in the case of our hypothetical, a corporate entity that is not licensed. And like I said, it's very easy to think of these two concepts as, being part and parcel of each other. Stephen, you mentioned that, in that New York Attorney General opinion, they parsed out how finances were divided. And we discussed in general how that is that could be a really, easy way to find yourself falling into the CPOM pitfalls, et cetera. But when it comes to fee splitting, what we point out is, like Stephen said, Florida as a state doesn't necessarily have a corporate practice of medicine prohibition, but they do have a fee splitting prohibition. And so the complying with one does not necessarily mean that you're automatically compliant with the other. And so we would call it out because it could probably be the subject of its own triage, but we want to call it out because while you will likely encounter both issues as you expand, right? Because as you cross state lines, you will interact with them in different ways. It's important to assess them independently of each other to ensure that, the model that you're pursuing works within the concept of state law.
I think one other aspect, I think it was great talking about the division. So even if you comply with corporate practice of medicine, you still have fee splitting. But one of the other aspects of this is, it's called corporate practice of medicine, but it also extends to other clinician types. And a lot of people miss that. And, and it's the concept as Sarah was talking about historically is the quote unquote learned professions. And that's typically been medicine and dentistry, but many states have, addressed it in this context of physician assistants, nurse practitioners, mental health therapists, physical therapists. So it's a very expansive doctrine, depending on which state you're in.
That's really helpful to understand. I was just thinking about, as I was listening to the two of you speak, how much of medicine is, or how much of the regulations around healthcare in general is influenced by this desire to maintain independence of the decision maker, the licensed professional that's making decisions about what treatment to provide, what, if any, drugs to prescribe, and all those the host of decisions that come with that. Because even if we talk a lot about the anti-kickback statute with our clients in the healthcare space as well, which is not the subject of this podcast, but it makes me think of it as we're talking about corporate practice of medicine, because the underpinnings are very similar in trying to separate the influence, financial influence or corporate or profit influence from decision making, clinical decision making.
And Gina, you raise a good issue, because it's one of the questions I hear from companies is we're cash pay only. Can we evade all this corporate practice of medicine by doing a cash pay only model? And to your point, it's not like the kickback statute where you have to submit a claim to a government entity, or even like HIPAA, where you're, billing, engaging in certain HIPAA standard transactions. The focus of corporate practice of medicine is really on the provision of care, regardless of the payment mechanism.
And along with that, I'll emphasize it is a state law doctrine as well. So unlike, again, the federal anti-kickback statute, which is a federal doctrine, and then of course there can be some states that have what we call mini kickback statutes, corporate practice really truly is you're entering into a state law doctrine every time you have to look at it in each state, which is challenging, because then you're looking at, is there a law? Are there judicial decisions? Are there attorney general opinions? Is there enforcement action from the Board of Medicine or the Board of Dentistry? And it's really pulling together a lot of strands to understand then what are the guardrails or the parameters. And some states, I think, make that more clear than others. So super helpful. Well, jumping to, I think we've talked a little bit about why we hear a lot about CPOM since the public health emergency. And, I've touched upon that. Stephen, I wonder if you can help us understand how it has telehealth evolved since COVID in this space, and sort of what considerations are maybe different now than what we had to think about pre-COVID as it relates to corporate practice of medicine.
Sure. So Gina, I think, it's a great question, because what I view the pandemic, it basically was an accelerant on a lot of this. And so, whereas, as Sarah pointed out, a lot of this is protecting the physician-patient relationship and quality of care and clinical autonomy, as well as medical integrity. But with, the pandemic, it tossed everything on the head, because you didn't want a lot of patients in the physician's waiting room, right? And so there was almost this relaxation of the corporate practice of medicine. Many of the governors issued executive orders. Boards of medicine issued guidance on, encouraging telemedicine. And then, once the pandemic subsided, and those PHE, waivers went away, there's now this reassessment of the model and how it actually, works within the corporate practice of medicine doctrines developed by these states and the enforcement actions.
I know we're running short on time, and so I'll pitch this to either of you to talk about. And that would be really, what are the penalties for failure to comply with corporate practice? We've talked a lot about what it is and the underlying policies and why it's important to comply. But what happens if you don't comply?
Sure. So, at a minimum, you could have the state regulator, usually the AG, that could go in and basically force the corporation to, shut down, dissolve, wind up. So that's one aspect. You see that occasionally. Most likely, what you see is the board will sort of pursue the physician that's violated the prohibition. So that's one aspect of it, is the physician's at risk. In many cases, the board or the AG will invalidate, or the court will invalidate the arrangement because it violates the court. That's probably the most likely. And then the one that's sort of most interesting in my mind is the fact that commercial payers are using corporate practice of medicine almost as a sword to basically not pay providers in some instances. And what you see is, in some cases, they use commercial insurance fraud statutes in the state, and they say the provider submitted, fraudulent claims because their structure violated the corporate practice of medicine. And you've got a series of cases brought by Allstate in many states where they're trying to basically not pay providers and recoup money. So those are some of the penalties.
I'll add that when it comes to, and this is foreshadowing for episode 2, I think, but if you are the platform, right, you can't operate if you can't attract providers. And this compliance and these issues of penalties for providers in particular, you run into the possibility of impacting their eligibility for reimbursement with federal and state programs. And, as we know, that can have serious consequences on a provider's ability to practice. And so we want to keep in mind that while, and then of course, also the prohibitions or exclusions don't have to be limited to the provider themselves, right? We see individual, corporate employees, CEOs, we see, folks end up on exclusion lists all the time that, aren't the clinicians. But again, when it comes to this space, because the stakes are so high, particularly when we talk about Medicare and Medicaid eligibility, it's important to think about these things carefully and consult with counsel about how to make sure that you're not accidentally running afoul, because it's very easy to do, especially if you're coming into this from a non-CPOM state, or just not previously having to consider this because you haven't operated in this healthcare space previously.
Well, thank you, Sarah and Stephen. That's a great conclusion, both of you, just in understanding some of the risks, both to the providers and to their livelihood, as well as to the entities themselves. And we look forward to our next session, where we'll talk more about the corporate practice of medicine doctrine, but more specifically, how entities can structure themselves to ensure compliance and some of the operational considerations that they need to be aware of as they're looking at structuring the way they deliver care, the systems they use, the whether they're employing or contracting with providers, and all of the host of other issues that arise. So thank you again. This has been a great conversation. This is such an interesting issue, and it really has become a renewed focus as healthcare continues to evolve and we continue to see more and more remote models emerging. We look forward to session 2. Thank you to our listeners for joining us. And we will come back with more on corporate practice very soon.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.